Pleased to have Glenn Haley from BCLP in Hong Kong and Tim Robbins from Robbins Arbitration in the Netherlands to discuss the Hong Kong perspective on the role of courts in arbitration. We thought today's discussion is very timely given the success of ICA in Hong Kong earlier this year and, of course, the upcoming Hong Kong Arbitration Week. As always, we welcome questions throughout, so please feel free to put them in the Q&A box, or otherwise we'll have some time at the end of the discussion and you can take yourself off mute and ask. And with that, I promised Glenn and Tim that I'd keep my introductory remarks very short, so I will pass over to them.
Great. Thanks very much, Carmel. Thanks to ICC Australia for having us, and a pleasure to share this with Glenn. A bit intimidating, of course, to have someone like Mario on the call, who I'm not sure if I should be lecturing on the role of the courts in Hong Kong, but anyway, we appreciate your attendance. And so I guess we'll get right into it. So to start off, as you know, obviously, Hong Kong is one of the leading global seats for years. It's been up there with the likes of London, Paris, and Singapore. It's, of course, no surprise. It's an international city with amazing infrastructure, a deep pool of legal talent, hosts multiple leading institutions, including the HKIC and the ICC's first overseas office. And so I thought Glenn could kick us off by, given the length of your commitment and experience in the jurisdiction, could you speak about the role that the courts have played and continue to play in Hong Kong's success as an arbitral hub?
Well, thanks, Tim, and afternoon, everybody. As Tim said, I'm a bit humbled to have Mariel listening on. I hope that I don't get any questions from her, but feel free, of course. If I could start just with the views I have about the judiciary in Hong Kong. I've been here 40 years now. Pro-enforcement, pro-arbitration, and minimal interference. That's the approach that the Hong Kong judiciary takes towards arbitration. And this has been demonstrated through the many repeated judgments, and we'll be touching upon those through some headline statistics later. And if time permits later, there's a number of recent judgments that Tim is going to take you through. Just from my experience with them, I have found them to be pro-enforcement, pro-arbitration, and minimal interference. That's the approach our judiciary takes. The judiciary here is aided in that regard by, we have a specialist construction and arbitration list where all High Court, which is our court of first instance, arbitration or construction matters will be put in that list, and in charge of the list is a single judge. So if you're in the list, unless there's scheduling clashes or overflow, the cases on the list will be handled by the judge in charge of the list. So you know that it'll be handled by someone who knows about the industries and the sectors and is experienced in them. And a lot of the judgments are written by that judge in charge. The first judge in charge of that list was Neil Kaplan, who you may have heard of or had experience with. And so Neil set us off on that good track. And it also assists to get consistency of approach over and above precedent, but just in handling the procedural and directional matters. Hong Kong's a model law jurisdiction, except that you can opt into some extra challenge grounds in Schedule 2, and I'll touch upon Schedule 2 later. So Hong Kong's current arbitration ordinance, which replaced quite a modern one anyway, is a model law piece of legislation. There's limited interference in the arbitral process that's specified in the ordinance. Things like staying court proceedings in favour of arbitration, ruling on challenges to appointments, granting the interim protective measures, assisting in the taking of evidence, setting aside awards, enforcing awards, and granting extensions of time, to commence proceedings if the tribunal hasn't already been appointed, and so limited grounds. A few extra ones for interference if we're into Schedule 2, which you must opt into, and I'll be covering that later. Just making good on what I said earlier about the minimal interference, just some enforcement statistics where the enforcement application goes to our Court of First Instance. In 2020, there were 51 applications to enforce and 7 applications to set aside awards, and there were only 2 successful applications to set aside. In 2021, 54 applications to enforce, 13 to set aside, and only 3 successful applications to set aside. So in practice, you can see that Hong Kong is pro-enforcement, pro-arbitration. Also, in my experience, Hong Kong has an independent, strong, and very capable judiciary. Very high caliber judges, well-written and reasoned judgments. And for all important judgments, they are written and published in English. So also very user-friendly, but a very capable judiciary. Under the mini constitution, which was put in place in Hong Kong, our basic law, which was put in place by London and Beijing at the time of the handover in 1997, there's a high degree of autonomy, which is guaranteed, and the independence of the judiciary. They are guaranteed in that mini constitution. And my experience is that the judges take that seriously. And also we operate under, we call it one country, 2 systems. So Hong Kong Special Administrative Region is part of China, as it should be now. And but we operate in 2 systems. The mainland, of course, is a civil law system. Hong Kong retains its common law system and common law background. And so all of the case law precedent that's been built up, unless it's changed by statute, is still applicable and in keeping with the common law background, is free to and does have reference to case law from other common law jurisdictions. The ultimate court and appellate authority in Hong Kong is our Court of Final Appeal, and it has 4 permanent judges who are all Hong Kong resident judges, but we have a large number of non-permanent judges of the Court of Final Appeal who are added in and sit with and help to write judgments on cases. And a number of those judges are also Hong Kong-based judges, but we also have judges of the highest caliber from other common law jurisdictions, and that includes from the UK and Australia. And the UK non-permanent judges are usually the Supreme Court, the old House of Lords. In Australia, it'll be our High Court, our highest court, or Chief Justice, or very senior judges from the Federal Court or the state courts. And so extremely capable senior overseas judges also sit with our Court of Final Appeal, which of course makes it will issue judgments on matters of great public importance, and that includes both criminal and civil matters. If you read any of our Court of Final Appeal judgments, you'll find that those judgments are of the highest caliber and extremely good academic rigor put into them. They are top-class judgments. That's all I wanted to say, Tim, about the role of the Hong Kong courts.
No, thank you, Glenn. That's yeah, and given my much more streamlined experience of just over a decade in the region, I can obviously concur. My experience with the courts has been nothing but a positive one, as you said. Extremely pro arbitration. The judges as well are extremely informed about arbitration. It's the specialist branch. They make sure that these judges know what the international standards are, and so that's been clear. And although not going into it today, despite some recent what might say political changes, I don't think that you've really seen any effect on arbitration and on the commercial courts and all that. Hong Kong maintains extremely well ranked in a lot of key metrics internationally. We looked at some of the reports from the World Bank Group and in their worldwide governance indicators, which were last updated in 2023. Hong Kong ranks third in Asia in respect of the rule of law and regulatory quality. It's also scores extremely high in the control of corruption, being in the top percentile globally in that report. And then as far as the World Competitiveness Yearbook that was published in 2023, Hong Kong ranked number 7 globally, and then also number 1 in global in business legislation, which has, I think, always been a strength of Hong Kong as well. Along with the courts, the government has been quite supportive of legislative efforts to support arbitration. So I think these metrics underpin the success that Hong Kong has had in building and maintaining its strengths as both an international financial hub, as well as which goes hand in hand, I think, with its success as an arbitration hub. And so moving on, we discussed, Glenn had mentioned briefly about Schedule 2 and teased a bit that it was something that one opts into. But for those that might not have been aware of the subject, Schedule 2 contains a number of additional provisions that are not found in the model law, which is what Hong Kong's arbitration ordinance is based on. So Schedule 2 includes a few additional powers, such as the power of the courts to make decisions on preliminary questions of law, to challenge an award on grounds of serious irregularity, and it includes a non-exhaustive list of those grounds, the right of appeal against an award on a question of law, as well as supplementary provisions on challenging to or appeal against an award, for example, for insufficient reasons. So Glenn, yes, can you expand on your views and experience with the provisions and whether, as you said, people have anything to worry about?
Okay, so in Schedule, if you want Schedule 2 to apply, you must opt in expressly. The parties must opt in. There were some transitional provisions where if it was a domestic arbitration, it would apply and would apply all the way down the contractual chain, but you must opt in expressly now. And that's is in contrast to Section 69 of the UK Arbitration Ordinance, which I think you must opt out of. I haven't practiced in Australia for many years, but I had a quick look at the uniform arbitration legislation there, and it seems that Section 34, capital A, which is appeals on questions of law, only applies if the parties agree that it applies. And so you must opt in. We did have quite a few opt-ins in the early days, because lawyers are cautious in nature and didn't want to give up the right to challenge an award that they disagreed with. And we had the automatic opt-in for domestic arbitrations because prior to the new arbitration ordinance and taking on board the model law, our arbitration ordinance here was in 2 parts, one for domestic arbitrations, which had all of the old challenges, and international arbitrations that only had the New York Convention and model law grounds of challenging. So I've been involved in a few applications for leave to appeal. By and large, the court here has been very reluctant to grant leave to appeal. It's a tough threshold as to whether, as to what the test is, and it is usually done on the papers and must be decided usually just by reading the award, no external evidence in. As for serious irregularity, the courts are very reluctant, in my experience and in the few cases I've been involved in, to allow you to challenge the award on that basis. Something must have gone seriously wrong and must have affected in almost an egregious way the rights of the parties. So that's just a quick taster on Schedule 2, Tim.
Great, thanks, Glenn. See that we're quickly running out of time. That is. So just perhaps the next topic before we perhaps get to the cases. We've discussed all the hallmarks of Hong Kong having leading arbitral jurisdiction, the pro-arbitration legislation, the pro-arbitration government, independent courts, all of that. But there are a few extra benefits that some people may or may not be aware of vis-a-vis arbitration with the courts. And so one of them is the supplemental arrangement, which on enforcement, which I think Glenn is going to touch on. Oh, still on mute.
I'm sorry, I just couldn't find the unmute button for a moment. Apologies. I will handle this in fact really quickly because, of course, now that the Hong Kong Special Administrative Region is part of China, the New York Convention can't apply to reciprocal enforcement of judgments between Hong Kong and the mainland, and that of course created a little bit of a problem because here we are common law, on the mainland is civil law, and we're one country, two systems, so we have our different legal systems. So how to enforce, because we couldn't use New York Convention. So extremely sensibly, the respective governments put in place an agreement that would and under which they would give reciprocal enforcements to each other's judgments, with the exceptions being effectively the same as in the New York Convention or in the model law, and so limited grounds in practice to challenge. There is a bit more I could say, but that's effectively what it is. And so the fact that Hong Kong's part of China again is not a disincentive. There's easy enforcement across the borders. In 2012 to 2022, since this first came into play, there's been 203 applications on the mainland to enforce Hong Kong awards, and all but 17 have been enforced on the mainland. 9 of those 17 were because there was no valid arbitration agreement, and the majority of the rest were for excessive jurisdiction.
Thanks, Glenn. Another benefit that we'll touch briefly on, and I think people might know about it, it's been a few years now, is the very wordy arrangement concerning mutual assistance in court-ordered interim measures in aid of arbitral proceedings by the courts of the mainland and the Hong Kong Special Administrative Region, which is a mouthful and a half. This came into effect in 2019 in October, and essentially what it is that it works both ways. So arbitration seated in China and arbitrators seated in Hong Kong, which we'll focus on, they will have the benefit of going basically directly to the courts of China to get interim measures. So if it's done before the commencement of arbitration, you can go directly to the relevant court, to the region where the respondent party is. And if it's after the commencement of the arbitration, you will generally get a letter authorizing you from the institution in Hong Kong. So this basically gives the parties the power to go to the Chinese courts, who can do any of the following: property preservation, freezing injunctions to preserve assets, evidence preservation, as well as conduct preservation, so mandatory or prohibitory injunctions. So there's quite a broad scope here. While the benefits are only available to counterparties who have assets or evidence within China, is actually, considering China's place as the world's second largest economy, and it's integral part of world trade and manufacturing, I think this is no small thing. Just to note that you need to have a qualifying institution in order to have access to this. So that includes the HKIC, the ICC in Hong Kong, CTAC has a branch in Hong Kong, as well as a few other smaller institutions. So just briefly, some of the statistics are actually quite impressive. So I'll just get the most important ones. So since it came into effect in 2019, The HKIC has processed, as of the end of 2023, they processed 105 applications. 99 of those were for the preservation of assets, so for the vast majority, and the total value of assets requested to be preserved amounted to around 3.7 billion USD. So as far as HKIC is aware, it's aware of 70 decisions following up from those, and of 70 decisions, 66 were granted for a total of $2.3 billion worth of assets being preserved. So it's quite effective. And also statistics, just to note, just over 60% of the applications in 2023 concerned assets owned by mainland Chinese parties, whereas almost 40%, the balance concerned assets owned by non-mainland parties. So Australia, BVI, Canada, Cayman Islands, Hong Kong, Singapore, Taiwan, US. So as I said, it's not just for having Chinese counterparties. It's quite useful for those parties to be seated, have arbitration seated in Hong Kong to have access to these. We said we were going to touch on some court decisions. I won't go into the details. It's always, fun to refresh and all that. But as we said, these decisions kind of just reinforce that Hong Kong is up to the standard with international courts as far as pro-arbitration, recent decisions on multi-tier dispute resolution clauses, which go to admissibility as opposed to jurisdiction, arbitrator immunity and getting evidence from arbitrators, high standard that we're expecting from pro-arbitration jurisdictions. And there was a recent award that dealt with kind of the whole gamut of the failure to deal with issues, failure to give reasons, errors of law, failure to present the party's case, or lack of opportunity. All of those dealt with in a way that obviously we expect a pro-arbitration jurisdiction. But that said, some of the, being pro-arbitration doesn't mean that you're automatically going to enforce all decisions. Where necessary, the courts have shown the level of sophistication and principle necessary to refuse enforcement of award where it is necessary. Sorry, so that was a brief overview there. I see Carmel has popped back on. I'm not sure if Glenn, if you want any final comments before we pass it back to Carmel.
No, the only thing that I would say, Tim, is that special arrangement between Hong Kong and the mainland about the reciprocal, the granting of mutual assistance. It's the only, Hong Kong is the only one that has an arrangement of that type with the mainland. So if you are advising a party that's arbitrating against a mainland party, Hong Kong has a unique advantage if you think that any interim measures would be needed.
Thanks, Glenn.
Thanks, Tim. Thanks, Glenn. We want to open it up now to everyone who's dialed in. If anyone has any questions, comments, or wants to share their own experience with Hong Kong courts in arbitration.
If nobody pops in, there's one of the cases that I want to talk about that had a personal connection to a case that I had, and it's one of the non-enforcement cases. So there was a respondent he was a respondent in arbitration. He'd been arrested in mainland China and imprisoned 3 months prior to the notice of arbitration being issued. Arbitration continued without him. Award was issued, and several years later, when he got out of prison and enforcement proceedings were going on, he actually went to Hong Kong to have it set aside. And the court of first instance set aside the award because it found that the plaintiff was not given proper notice of the arbitral proceedings and was not able to present its case due to the incarceration in mainland China. And I think it probably played in that the claimant party was aware of this, but did not make efforts. What was interesting is I actually had a case where it became known to me as arbitrator halfway through the case that the respondent had been in jail in China since before the start of the proceedings. So had to wind things back, inform the other party about this precedent and whatnot. So yeah, just thought I'd share that.
Thanks, Tim. I can see Mariel's put her camera on. I feel like that's inviting me to throw the spotlight to Mariel.
I actually have a question. And this is to Glenn because you've been in Hong Kong for so long. And, I know we're not discussing politics today, thank goodness. But one of the things that I always hesitate with is the way the courts are going, and with 30 years of experience, I mean, I've been in Hong Kong for just under 9 years, so, and very far away from the courts in terms of my practice, but I'd be interested to know from Glenn whether you've seen, obviously, people leaving, but in terms of actual commercial decisions over the last 30 years and staying away from the national security law, whether you have any concerns about the direction that's going in, because I find it very, very easy to talk about arbitration in Hong Kong and why it's still good and why it's still reliable and neutral and all those things. But every time something happens in the courts, it makes me quite nervous because it's a very small leap to arbitration from the courts. So having been there for so long, and in light of the last sort of 5 years, I'd be really interested to hear your views on whether you think that's actually changing or not.
I don't see any change as to how our judiciary handles cases, makes decisions, including if they are cases involving Hong Kong government. The judiciary here is fiercely independent, and nothing that I've seen or been involved with causes me to think that there's been any change in the judiciary's approach on commercial and civil cases.
That's good to know.
I still have full confidence in our judiciary here, as I said earlier, stocked by competent and jurists who write well-reasoned and solid judgments. And we have a robust Court of Appeal and an excellent world-quality Court of Final Appeal.
And as you said, Mario, obviously we're not getting into politics here. Whatever the motivations behind decisions that people see in other aspects of Hong Kong law and courts, that motivation, for lack of a better word, does not carry over to the commercial courts in what I've seen. And I actually think that it's an opposite incentive is there, because the keeping Hong Kong as an international business center, keeping the commercial courts independent and all that, and if anything, there's kind of a heightened desire for that, I would assume. And again, based on my more limited experience, I've not seen any shift either.
And also, earlier this year, I was part of a delegation that went to the UAE and Saudi Arabia with our current Secretary for Justice. And he is very pro-arbitration, and I had a number of discussions with him, and every interaction I had with our current Secretary for Justice and the predecessors, in fact, also fills me with confidence, Meryl, that the independence and the high caliber of the Hong Kong judiciary will just continue.
That's very reassuring. I saw that you were part of that delegation, Glenn. It looked like a very interesting trip.
It actually was, although we packed a lot into it. Meryl, we were all a bit tired at night.
Any other questions for anyone dialed in?
I will say that Canada also, as Glenn had discussed, the foreign non-permanent members of the court, Canada's former longest-serving Chief Justice, Bev McLaughlin, also has been on the court for a number of years now. And obviously, there's been a few people who stepped away. She is ending at the end of her current term, but as she announced her retirement, she did say that she has full confidence in the court's independence as well, and that she's retiring because she's 80, and I think that's a reasonable reason for stepping back.
We're just coming up, we're right on time actually for finishing up. Glenn, Tim, are there any final remarks you'd like to make before we wrap up?
No, only thing I'd say is that if you haven't visited Hong Kong recently, please get up here and say hello. And if at the early April next year you have a week to spare, come up and help us with the Viz East student moot. We always welcome arbitrators to come. Have to pay your own airfare, of course, but it's a wonderful week. So please come and join us. Join the fun.
I echo that. It's been 2 years now since my partner and I relocated to the Netherlands, although I maintain business address in Hong Kong, and I get back as often as I can for both Arb Week and for the VIS and other events, because yeah, it's not just an amazing arbitration community, it's obviously an amazing city as well.
Thanks everyone for joining us, and to Glenn and Tim for a very interesting and timely discussion. I just want to wrap up today with a very quick plug for our next episode. We're very excited to be having our first in-person episode next month, which is happening at Australian Arbitration Week on the 15th of October at 9:30 a.m. So for those of you who will be in Brisbane, we look forward to seeing you there. Thanks, everyone.
Thanks, Carwell. Thanks,
See you
everyone.
there.
Great to see you.
Thanks.
Thanks
Thanks
very much.
everyone. Bye-bye.
Bye.
Thank you. Bye.
Thank you.
Everyone.
Thank you.